Hancock, Daniel, Johnson, and Nagel. We are pleased to present to you today on the Virginia Healthcare Decisions Act. This presentation is in honor of National Healthcare Decisions Day, which falls each year on April 16th and aims to help people across the United States understand the value of advanced healthcare planning. As a quick disclaimer, we are obligated to inform you that this presentation is not intended to be legal advice. HDJN is offering this presentation as an educational opportunity to learn more about Virginia's laws and advance directives. You should contact legal counsel if you have questions when applying the law to individual facts and circumstances.
Under Virginia law, there are actually several different mechanisms that a person can use to make their healthcare decisions known in the event they become incapable of making decisions later in life. We're going to be talking predominantly today about advance directives, which are written documents in which you're able to make healthcare decisions known. But there are a lot of other mechanisms that a person can use that you should be aware of. In Virginia law, we actually have statutory substitute decision makers, and these are people in your family who can make healthcare decisions in the event you're no longer able to do so. Now, with advance directives, we actually have two components. The first is sometimes referred to as a living will, and that's where you include the specific decisions regarding healthcare that you would like to make known and like to have honored in the event you're unable to make decisions later in life. Now, you could also appoint a healthcare power of attorney or an agent to make your healthcare decisions for you in the event you no longer have capacity to make those decisions as well. We also have durable do not resuscitate orders, or DDNRs, which are simply orders that prohibit persons from providing CPR to you in the event you have a cardiac or respiratory arrest. And then there are also court mechanisms that a person can use to make decisions, such as a judicial authorization for treatment or an appointment of a guardian to make decisions for you. We're often asked why a person should create an advance directive. And the easiest answer is that it makes your healthcare decisions known in the event you can no longer communicate those decisions, or you're incapable of making those decisions for yourself. Advance directives are useful for people of all ages in any current healthcare status. They're not only used for terminally ill patients or the elderly. Instead, they can be used in the event that you do have an accident or a sudden onset of a medical condition. They make sure that your healthcare choices are honored by your family and your healthcare providers. And you can also appoint a person to make healthcare decisions for you in the event that you become unable to do so. This reduces the burden on your family and any potential conflicts among your family members or loved ones. It also makes clear your wishes to healthcare providers and physicians so that they can follow your wishes. You may be aware that there have been numerous cases in recent years discussing end of life care. For example, in Texas, in November of 2013, a pregnant woman suffered an embolism and was declared brain dead. She had informed others, including her husband, that she never wanted to be on life support, but unfortunately she had not created an advance directive to document her wishes. The hospital kept her on a ventilator despite the family's wishes because of an interpretation of Texas law and a fear of liability. The law actually prohibited the withdrawal of life-sustaining treatment from a pregnant patient, and the issue was whether the patient was actually legally dead, and in fact, whether she was a patient of the hospital at all. It took 2 full months for the husband to obtain a court order to cease life support. This likely would not have happened in Virginia because we do not have the same provision of law, but it illustrates the importance of persons to make their healthcare wishes known in the event they lose capacity and are unable to make decisions. Virginia does have a relatively new legislation that was passed in 2015 that addresses a pregnant patient in their advance directives. And we didn't follow Texas's example by prohibiting the withdrawal of life-sustaining treatment for pregnant patients. Instead, we added an optional section to an advance directive form for patients to list the specific instructions they would like or modifications to their other instructions regarding life-prolonging procedures if patient is pregnant and has a terminal condition. I want to provide an overview of Virginia's Healthcare Decisions Act. It was originally enacted in 1983 and has changed drastically over the years. And when first enacted in 1983, it was in response to ethical debates happening all over the country regarding end of life decisions. Many people are aware of or have heard of the high profile cases of Terry Schiavo in Florida and a similar case that occurred nearly a decade earlier involving a man named Hugh Finn. In Schiavo, the issue was the removal of Terry Schiavo's feeding tube. Ultimately, the conflict was reviewed by two state courts, a federal court, the federal legislature, the Florida state legislature, and even the Florida governor. Ultimately, the decision was made to remove her feeding tube, and she passed away. The Hugh Finn case happened roughly a decade before Schiavo and was in Virginia. Mr. Finn's wife and family members argued over the decision of whether to remove Mr. Finn's feeding tube. Our governor, the Virginia governor at the time, Governor Gilmore, intervened, and the case proceeded all the way to the Virginia Supreme Court. Ultimately, the feeding tube was removed, and Mr. Finn passed away. I'm sharing these cases with you to illustrate the point that there can be extensive court battles between family members that can drag on for 10 to 15 years. If any of those individuals had completed an advance directive, well, likely those disputes would have ended 10 years prior, reducing much of the emotional and financial strain on the family. I want to point out the original Healthcare Decisions Act that was enacted in 1983 only addressed the appointment of healthcare agents and the acceptance or rejection of life prolonging procedures if the patient was suffering from a terminal condition. And we've had some substantive changes to those acts that we're going to address, and you're now able to decide what type of healthcare a person does or does not want, and you can make those wishes known and documented to ensure that they are upheld. These changes were first enacted in 2009 and were later clarified in 2010. Advance directives now in Virginia are not limited to patients suffering from a terminal condition or just life-prolonging procedures. They now may address any and all forms of healthcare treatment at any stage of life. Now, I want to take a moment and go over some of these substantive changes. And as I said, they expanded the scope of the Advance Directive, but they also provided for advance authorization of mental health treatment. They also added a patient protest provision. It's become known as the Ulysses Clause, where you can actually dictate that in the future you would like a decision to be made over your later protest. We're going to talk more about that in later detail. The changes also strengthen the capacity determinations that must be made by two specific examiners before an advance directive becomes effective, and added a requirement that recertification of capacity must be done every 180 days. The changes also clarify revocation provisions for both advance directives and do not resuscitate orders, and they clarified how a person may make an anatomical gift through an advance directive or authorize research. One primary provision that expanded the scope in advance directives was simply the definition was added to the term healthcare. The definition of healthcare now, which can be designated in an advance directive, includes any instructions, including medication, surgery, blood transfusions, chemotherapy, radiation, psychiatric treatment, life-prolonging procedures, palliative care, and even admission to a specific nursing home or other healthcare facility. An advance directive now may provide specific or very general instructions regarding the form of treatment that the individual wants or does not want, or even where the individual wants to be treated. Generally, an advance directive does have to be made by an adult who is making an informed decision. They only then become effective when that person is determined to be incapable of making an informed decision. We'll talk more about that momentarily. An advance directive may provide specific instructions regarding treatment, or what's commonly known as a living will, and they also may appoint a healthcare agent or a healthcare power of attorney to make those decisions in line with the instructions listed in the advance directive, or alternatively, if none are directed, in line with the person's best interests and their understanding of their religious beliefs. As I stated, you can also specify an anatomical gift or authorize your participation in research activities. Another major change in 2009 and 2010 addressed mental health treatment and how a person can make their wishes known if they're later determined to be incapable of making a decision. So now, it can be used for mental health care. A patient's agent can actually consent to a patient's admission to a mental health facility for up to 10 days, but only if the patient's advance directive expressly permits this type of admission decision, and also that the admitting facility certifies the patient has a mental illness, is capable of making an informed decision, and in need of treatment. Of course, finally, the facility must also be willing to admit that patient. As mentioned previously, the Virginia Healthcare Decisions Act specifically defines what it means to be incapable of making an informed decision. And that requires a physician to actually determine that a person is either unable to understand the nature, extent, and probable consequences of a proposed healthcare decision, or that the patient is unable to make rational evaluation of the risks and benefits of a proposed healthcare decision as compared to the risks and benefits of alternatives to that decision, or finally, that the person is unable to communicate such an understanding in any way. Now, it's important to know that communication disorders do not qualify. If an individual can communicate in any other way to make their treatment decisions known and are able to understand the risks and benefits of that decision, well, they should be allowed to make decisions for themselves, and you should not rely on an appointed agent. Also, poor judgment does not qualify as being incapable of making a decision. So, simply because your family members may not agree with the decision you make or may not understand it, you are capable to make that decision yourself, then you will make it. So, how does a person actually become declared incapacitated to make their own decisions? It must be certified in writing by a patient's attending physician and either a second physician or a psychologist after a personal exam of the patient. That second physician or psychologist may not otherwise be involved in the patient's care unless such person cannot be reasonably found. And there is one exception here where the patient is clearly incapacitated, and the exception states that the second physician or clinical psychologist certification is not required if the patient is unconscious or experiencing a profound impairment of consciousness due to trauma, stroke, or other acute physiological condition. If those circumstances are met, then only one physician is required to certify lack of ability to make decisions. When that determination of incapacity is made, there are certain things that the patient does have a right to know, to the extent possible, and that is that they should be notified that the determination has been made before any health care is provided, continued, withheld, or withdrawn. The notice must also be provided to that person's agent or surrogate decision maker, and only one physician is required to make a determination that the patient has regained capacity. So if a patient has been declared incapacitated, only one physician is needed to overturn that or reverse that order and allow the patient to again make decisions on their own behalf. What does it take to execute a valid advance directive in Virginia? Well, the first requirement is that the directive be written. It should also be signed by the person when they are capable of making a decision. It must be attested to by two witnesses who both are 18 years or older and who are capable of making healthcare decisions of their own. Witnesses may also be, important to note, a spouse or blood relative, although many other states prohibit this. Also, a notary is not required, and copies are considered valid and will be followed by your healthcare providers. There are limited exceptions that would allow a person to make an oral advance directive, meaning the directive does not need to be written. And these are only permitted when a physician diagnoses a patient as having a terminal condition. And that oral directive must be stated in the presence of an attending physician, and again must be stated in the presence of two adult witnesses. Also, the terminal condition must be caused by an injury, disease, or illness from which a reasonable degree of medical probability states that the patient cannot recover, and the patient's death is imminent or the patient is in a persistent vegetative state. And I want to give some practical recommendation here in terms of completing an advance directive. You don't want to make your healthcare agent also your witness, and that's simply to avoid conflict of interest. It's also not required to date your advance directive. Provide a date when you execute it, but we do recommend it in the event that you do have another advance directive later on. And so, if presented with two potential directives, it's important to know which one is more current and also which one would therefore be binding. In Virginia, we do have a recommended statutory form for the advance directive, and it's not required to use that form, but it is important to note that it's a writing and it meets those requirements that must be met in order to have a valid advance directive. So we do recommend using this one because it contains all the elements and has clear language. And also important to note, your healthcare providers are used to seeing the statutory form. And as you see, this is the first page on this slide of the advance directive template form used in Virginia. And you can find this form on the web link there and also in some of the other resources that we've provided towards the end of this presentation, which I'll point out momentarily. I now want to provide a few thoughts on what type of decision maker should be appointed, or some consideration points if you are appointing an agent. Now, first, you need to pick someone who's 18 years of age or older and is capable of making a decision. You'll also want someone who's accessible. They don't need to live in Virginia, but you'll want them to be reasonably accessible at least by phone in the event you lose capacity. You also want someone who's willing and able to serve and who's aware of your wishes and your religious beliefs. If you don't tell that person they'll be serving as your healthcare agent, imagine it would come as quite a shock when they find out later on and are expected to make decisions. It's also best to pick one agent, because collecting several people can lead to conflict or delay if they have equal decision making authority. Essentially, imagine if you pick two people. If they're not able to agree on a person, you actually will not be able to have a decision made at all. You can also require your decision maker to consult with other family members before making a decision. You can also choose alternate or backup persons to serve in the event that your healthcare agent is not willing or able at the time. I now want to address who makes a decision if you've not appointed a healthcare agent. As I mentioned earlier, there are Virginia statutes that dictate a list of people who can serve as the surrogate decision makers in the event you've not appointed a healthcare agent. This list on the slide is in order of priority. So essentially, you look to the top of the list, and if there's a person in that spot, they'll make decisions for you. If not, you continue to go down the list until you find a person who's available and willing to make a decision. The list starts with the guardian as a person appointed by the court to serve your best interests. If there's no guardian appointed, it'll be the patient's spouse next, unless they're separated or a divorce is pending. If none, you then turn to any adult children of the patient and next to any parents of the patient. After that, you turn to the patient's adult siblings and finally any other relatives in descending order of blood relationship. We also have a provision in Virginia law that would allow a special friend to make limited decisions with a few exceptions that we'll address in a moment. Now, this list, as I stated, is in order of priority. And if you have multiple people within a certain class, say, for example, you have two adult children, then the majority would have to rule. So, two adult children, and if there's no agreement, then no person has decision making authority. And without seeking a court order or a guardianship, no decision can be made. In Virginia, we now have a provision for a special friend who can make a decision for you in the event you become incapable of making decisions. The friend has to serve and have exhibited special care and concern for you and must be familiar with your preferences and values. The friend cannot make decisions regarding the withholding or withdrawal of life-prolonging procedures, and they cannot be employed by the facility providing you care. These people are often neighbors or close friends of a person who are taking care of them, but are not family members. All healthcare agents or surrogate decision makers have certain duties when they make their decisions on behalf of the patient. Healthcare agents and substitute decision makers must make decisions by undertaking a good faith effort to ascertain the risks and benefits and alternatives to any proposed healthcare. They must also make a good faith effort to ascertain the religious beliefs, the basic values, and the previously expressed preferences of the patient. And to the extent possible, they must also base those decisions on those belief values and preferences of the patient or on the patient's best interests. Virginia law makes it very easy to revoke an advance directive. A person can revoke by signing a written revocation that expresses the intent, or even by executing a new advance directive that's not consistent with a prior one. A person can also physically revoke an advance directive, meaning essentially any method used to destroy that document, such as tearing it up or shredding it. And finally, you can orally revoke, which is defined as making an expression of the intent to revoke. I spoke earlier on the Ulysses Clause, or how healthcare may still be provided over a patient's later protest. And there are now provisions for this in Virginia law. Healthcare may be administered over a patient's protest if that care is specifically authorized in the patient's advance directive, even over later protest. If the provider has actually certified that the patient had capacity at the time the advance directive was made, and typically this is documented right on your advance directive. Also, the decision does not involve life-prolonging treatment. And finally, the healthcare issue has been documented as medically appropriate by the attending physician. There are also other mechanisms to allow your healthcare agent or substitute decision maker to make a decision over your later protest, even if you haven't mentioned it in your advance directive. The certain criteria to be met are first off that the decision does not involve life-prolonging treatment. The decision also cannot involve admission to a mental health facility or mental health treatment. Also, the decision must be based on the patient's beliefs, values, and expressed preferences, if they're known, or the patient's best interests. And finally, it must be affirmed and documented as either ethically acceptable by the patient's patient care consulting committee, or alternatively, if the hospital does not have such a committee, it must be affirmed and documented by two physicians who are not involved in the patient's care. In Virginia, we have reciprocity with other states, which means that we will honor an advance directive that has been executed in other states, and vice versa. The advance directive simply needs to either meet Virginia's requirements or the requirements of the state in which it was executed. If this is the case, the advance directive will be honored by your healthcare providers here in Virginia. Now that you have executed an advance directive, how often should you review that directive? Optimally, you should look at it annually and determine if the wishes you've listed in your advance directive are still up to date and current, and if you approve of your healthcare agent. Another good time is before each annual physical. It's also helpful to know now that Medicare actually provides payment to physicians to have end-of-life treatment decisions. And if that treatment decision or end-of-life decision takes place during the annual wellness visit authorized under Medicare, it's considered preventative, and therefore a patient's coinsurance and deductibles are waived. Another good time to look at your advance directive is at the start of each decade of your life, or after any major life changes, such as a birth in the family, or marriage, divorce, or the death of a loved one. You may also want to look at advance directives after any major medical change, such as a diagnosis of a terminal condition, or of a heart condition, or other events that make you think about your end-of-life care. You may also look at your advance directive after losing your ability to live independently, or any time your wishes regarding your medical care may change. Now, where should you keep your advance directive? You should give a copy to your agent, that's your healthcare power of attorney, so that first off, they know that you've appointed them. That's very important. And they also know the wishes that you've expressed in your advance directive and are familiar with them. It's also a good idea to give a copy to your physician who will be directing the care that you will or will not receive when you become incapable of making those decisions. You may also want to give a copy to other family and friends, even if they're not your healthcare agent, so that someone will have a copy in the event something happens and you need someone to provide a copy to healthcare providers. You may also file a copy with the Virginia Advanced Directives Registry, which we'll discuss further in a moment. You should also bring a copy of your advance directive with you to the hospital whenever you're going for a planned procedure or, if possible, for an emergency condition. You also want to keep a copy in a safe place, but this does not mean actually locking up a copy in a safe or a lockbox where no one can access it in the event you need it. And I spoke just a moment ago about the Virginia Advance Directive Registry. This is an online registry that was created in 2011 and permits Virginia residents to securely store their advance directives online free of charge. The link in this slide contains information to help users create the advance directive right there on the website and to upload scanned documents they've executed. You can also send in your advance directive via fax. Information in the registry is only accessible to those who have your PIN number. You can also designate that a person should have read-only access, and that means that person cannot add or delete or modify documents, but instead can only view the documents in the event they need them in the future. In Virginia, healthcare providers do not have automatic access to the registry, so you cannot count on going to the hospital and having your healthcare provider search the registry for your directive. You should also keep in mind that the Advance Directive Registry requires you to actually actively renew these documents on a yearly basis. To that end, the registry will automatically send a notification about the new renewal prior to its expiration. And if the user does not reply within 6 months, the account will become inactive. So it's important to respond to registry emails and confirm that you are still, in fact, seeking to maintain an advance directive on the registry. I'm going to speak briefly about durable do not resuscitate orders. These are DDNRs. And they're not the same type of document as an advance directive, and they're actually very limiting. We could spend an entire presentation on DDNRs, but today I'd just like to speak about the differences from advance directives. A do not resuscitate order, or DDNR, is simply an order from a physician, and it says that CPR is not to be performed on you in the event you have a cardiopulmonary or respiratory arrest. It does not speak to any other type of healthcare treatment other than CPR. So in essence, you cannot state that you'd not like to have chemotherapy or radiation therapy, or that you'd like to be admitted to a mental health hospital, for example. It only discusses CPR and the fact that you would not like it performed. Further, a durable do not resuscitate order, or DDNR, does not have reciprocity with other states. If you have one executed in Virginia, it will be considered invalid if you leave the state. Like with much of the nation, Virginia is also experimenting with a new type of order called a Physician Order for Scope of Treatment, or POST. This form is like a DDNR because it's an actual physician order that indicates what treatment you do or do not want performed on you. It's broader than a DDNR and more like an advance directive, however, in that it can include instructions for medical interventions, antibiotics, artificially administered hydration, nutrition, and so forth. The POST is intended to be transportable from one hospital to another or from a nursing home to a hospital. However, in Virginia, the POST form is not a statutory form, so it has not been authorized by our Virginia General Assembly to be used in a healthcare setting. It therefore is only valid in the single hospital or other healthcare setting in which it was executed. Finally, I've provided this list of slides, which I find to be extremely helpful in providing resources on advance directives. These slides will include the advance directive template forms from the Virginia State Bar website, also contain background on advanced directives and advanced care planning. And the Connect Virginia link in the middle there, at connectvirginia.org/ADR, will take you to the Virginia Registry, which we discussed.
Thank you for your time today. We hope you learned something new about advanced care planning and advanced directives in Virginia, and that this presentation encourages you to consider completing an advanced directive or revisiting your existing advanced directive to ensure it reflects your wishes. Thank you.